Okay, Miss Sultan, you're back. And I see that you got, well, dad or potential father served. What's your name, sir?
My name is Stephen Pippin.
Mr. Pippin. Okay, you understand why you are here today, right?
Yeah, unfortunately.
Okay, you know I ordered you to have DNA testing done a month ago,
Yes.
and so we can determine child support, what it's going to be in this case. And I don't have anything from the testing center showing that you showed up. So what's going on
That's
with
because
that?
I didn't take it. I mean, I don't know what she's talking about.
So I order you to do something. This is not about her right now.
Welcome to Judge Bench, the courtroom where real decisions are made and real lessons are learned. If you haven't already, hit that subscribe button and turn on notifications so you never miss a case breakdown that could change the way you see justice. Today's episode is one for the books, the Sutton case, where personal accountability meets the power of the law. In this case, Judge Vonda B. presides over a matter involving a mother, Ms. Olson, and a man, Stephen Pittman, who is potentially the father of her 5-month-old child. As the court comes to order, Mr. Pittman is sworn in, and things take a sharp turn early on. He had been ordered a month prior to take a DNA test to determine paternity and thus child support obligations, but he failed to do so, arriving in court without a single document or explanation of compliance. Instead of showing up prepared, he tells the judge that he simply didn't take the test. He questions the need for it because he doesn't think he's the father. The judge, unimpressed with his nonchalant attitude, reminds him that it's not about what he thinks.
Oh,
And I'm a full-time student.
oh, okay.
So I don't have time for the games and all this testing, DNA testing, all that. I don't have time for it.
All right, so you work every day as a waiter.
Yes.
Did you bring anything today to show that you're waiting tables? Any type of financial
Nah,
information?
I ain't bringing that.
Oh, so you didn't care about that either. So did you bring anything to show that you're enrolled as a full-time student?
Nah, I ain't bring none of that.
So you just came to court unprepared today and you just think I should go along with that, right?
I mean, if that's what you want to call unprepared, yeah.
It's about what he was ordered to do. The judge explains clearly. When someone is ordered by the court to complete a DNA test and they fail to do so, the court is legally permitted to enter a default judgment, meaning they can deem the person the legal father by default. Mr. Pittman tries to defend himself by saying, he's busy, he works as a waiter, and is also a full-time student. But when the judge asks for proof of employment or enrollment, he's got nothing. No pay stubs, no class schedule, just excuses. He says he started working as a waiter 4 months ago, right after quitting a job that paid him $63,000 a year. Coincidentally, he quit that job just 1 month after the child was born. The judge questions the timing, wondering aloud whether Mr. Pittman may have left his job intentionally to avoid paying child support. He denies this, but the timing raises red flags. The judge points out that his actions, quitting a well-paying job just as he could be facing support obligations, don't make a strong case for someone who's trying to be responsible. Even worse, his attitude in court shows a lack of respect for both the mother and the legal process. When asked why he didn't comply with the court order, he shows little concern, saying he didn't have time for games like DNA testing. But as the judge clarifies, this is not a game. This is about the life and well-being of a child.
When did you start working as a waiter?
About 4 months ago.
What did you do 4 months ago?
I had a full-time job working as a consultant.
All right. How much money were you making?
$63,000.
Hold on. How did you say your baby was?
5 months.
5 months. And you just stopped working there 4 months ago?
Yeah, they had some layoffs, and I kind of thought that they were going to start laying some people off, so I decided to go ahead and quit.
So you quit? Mm-hmm. You didn't quit because you figured she was probably going to put you on child support?
Nah, I just...
Are you sure about that?
Because Mr. Pittman ignored the court's directive, Judge Vonda B. declares him the legal father by default. That means, regardless of DNA proof, he is now financially responsible for the child. The court calculates his support obligation based on his prior income, $63,000 a year. His monthly gross is estimated at $5,250, with a net income of $4,226.99. Since he has no other children, The judge sets his monthly child support at $845. On top of that, there's the matter of health insurance. The mother carries the insurance for herself and the child, totaling $750 a month. Since the father is only responsible for the child's portion, the court splits that in half, assigning Mr. Pittman an additional $375 monthly obligation. His total monthly child support payment is $1,220.
The father, because I ordered you to go and get DNA testing. So we could have found that out today. But you know what? We don't have to do it. You know why? Because I can deem you the father today because I ordered you to do it and you didn't do it. Question.
Yeah, it's me.
You carry health insurance.
Yes,
How
ma'am.
much is it?
$750.
$750. Does that include you and the child?
Yes, it does.
Okay. So what I'm going to do is split that in half. It's on $63,000 a year. I have your monthly gross at $5,250. That brings your net to $4,226.99. Your monthly child support obligation at $845. Your monthly obligation is $1,220.
Mr. Pittman tries to argue that it's unfair to use his old salary since he's no longer employed in that position. But Judge Vonda B. doesn't buy it. She makes it clear the court will not reward someone for quitting a stable job to dodge parental responsibilities. If he wants to present evidence of a legitimate income change, he'll have to do it the right way, by showing up, prepared, and filing for a modification. Until then, $1,020 is what he owes. That amount will be deducted directly through a state agency. He won't have the option to withhold it or delay it. As the hearing wraps up, Judge Vonda B. gives a final word of caution, not just to Mr. Pittman, but to everyone watching. Showing up to court unprepared and defiant can backfire in the worst way. This is not a space for excuses. It's a space for truth, responsibility, and justice. And in this case, the child came first, as it should. Thanks for watching Judge Bench, where justice isn't just delivered, it's explained. If you found value in this breakdown and want more real courtroom moments and deep dives, don't forget to like this video, subscribe, and click that bell icon so you never miss another session. Until next time, stay informed and stay responsible.